Okay, got a good number of folks already in here. Cool, cool, cool. All right, everybody. Welcome to our all things TCPA webinar. Welcome, everybody. It's me, your host, Gus. But but not by choice, but I'm actually doing this from my car today, right? Had to, a little bit of another story I'll tell for another day. I had to jump in the car quickly. But we're here. We made it. Didn't want to miss this one because I got a great one for you today. We've got, Eric Allen, who is a very knowledgeable attorney when it comes to TCPA, U.S. telemarketing law, compliance, everything to do with that. I'm a fan. I follow his newsletter very closely. I really recommend that newsletter, but it always has, it always has the scary stuff in there. I don't know if that's, good or bad. I like to know the truth, right? I like to know how things are happening because it'll tell you all the different, TCPA lawsuits, right? DNC lawsuits, compliance lawsuits, all these. I think it's interesting. I've been following him for a really long time. So Eric, a quick story. Eric did the first DNC audit for our company, Power ISA. This was a few years back. And, because we had, run into, I want to say, we didn't have any lawsuits. We had a few different DNC demand letters, right? Because we were just not doing things the right way. And once Eric kind of helped us put a little bit of order in there, it's been, several years now, several million calls later, and we haven't had one. Okay, we haven't had one issue with that again. I'm here to tell you, Eric knows what he's talking about, right? He knows his stuff, and he knows how to advise business owners and help protect us, right? And stay compliant. And more than compliance, I wanted to. It's also about risk management, right, Eric? So, anyways, that's the intro, right? That's my pitch to why you should listen to Eric today. And Eric, why don't you introduce yourself? Tell us a little bit about who you are. Why'd you get in, specialize in this area of the law? That's really interesting. And tell us about your whole trajectory. Go for it.
Sure. Thanks, Gustavo. If you get in a car accident, I know some good litigation defense attorneys.
Yeah.
I'm Eric Allen. I'm the managing partner at Allen, Mitchell and Allen. We opened this firm about 15 years ago, specifically to represent telemarketers, lead generators, data brokers, software dialer vendors, anybody that touches or uses or benefits from the telemarketing space. And that's all we do. We don't do any other type of law. We also don't represent plaintiffs or consumers. We only advise and defend businesses and defense. So we used to do a lot more litigation. Now our practice is about 75-25, so 75% compliance, prevention, keeping our clients out of court. Webinars like this, Q&A, opinion letters, 50 state charts on things like disclosure, curfew, licensing, and anything you can think of. And then to a lesser extent, we still defend TCPA and similar class actions in federal courts across the country. We're based out of Salt Lake City, but we have a national practice based on Florida law, and we're regularly admitted in federal courts. I think I've been admitted in probably almost every state by now for one case or multiple. Anyway, before I went to law school, I worked on the phones
Wow.
doing telesales for many years. So I grew up on the phones and transitioned more to the floor manager, trainer side. And then eventually I said, you know what, I was getting into compliance and I had a paralegal job as well. And I thought, you know what, I should just go to law school. So I went to law school. Even in law school, I worked for a big timeshare company in Las Vegas doing their compliance that we had, I think, 5 or 6 internal call centers and then a bunch of outside call center vendors
There you go.
setting appointments for us. Our practice, we represent a lot of verticals, but real estate prospecting and more recently home buyer wholesaler type calls have been a big part of our work. Real estate agents have had great success, as you know, telemarketing, texting, and some great challenges, the do not call list, making sure you honor opt-outs, using the right technology. And of course, next week on the 27th, we've got this brand new FCC rule, the one-to-one consent rule. That name is a bit of an oversimplification, but that's probably the most important part of the rule. I'll try and give you some silver linings. There's at least 3 that I can think of. 2 trade associations have challenged the new rule. We've also got a relatively limited definition of an auto dialer, thanks to the U.S. Supreme Court a few years ago and Facebook's big appeal. Um, but yeah, that's me. We want to be a resource to you like we have for Gustavo. I'm not going to give legal advice to anyone other than my engaged clients, but I want this to be informational. Check with your own counsel, but I'm hoping I give you a good push in the right direction and ask all the tough questions you want, and we'll give you straight answers.
Great, great, awesome. And for the folks who want to participate, have a specific question, you can drop it in the chat. That's the benefit of joining this call live. You can get your specific question answered. I've got a few questions. I'm the voice of the customer. If you guys are a little bit shy, I know what you guys are thinking. I know what you guys are asking. So, but if you have a specific question or drop it in the chat, and if we have time, we'll be happy to get to it. But my first question, Eric, let's set the table for the discussion, right? When we're talking about the one-on-one consent rule, the one-on-one consent update, right, the TCPA. Tell us, in a nutshell, you said that's an important part of it. There's more than that. How would you describe it to a layperson, right? A telemarketer, but we know we're not lawyers. How would you describe this update? What's changing in TCPA, and why, and how does it impact? And from your perspective, how does that change impact the real estate industry?
Good question. The biggest impact is that anyone calling on consent-based data. So this isn't so much about cold calls, but primarily about people who are calling on opt-ins. So if you're generating permission-based data on a website, or you're running a sweepstake, or you're buying opt-ins from a lead vendor, then you could be dramatically affected.
Gotcha.
So the standard for consent beginning next week on the 27th changes from a rule where you're allowed to get consent for many brands based on a single click of the mouse, for example, or a single affirmative action, to a new rule where the consumer has to specifically take an affirmative action like checking a box or clicking agree, etc., for every specific seller company who wants to call that lead. So in the past, you had big third-party lead generators. What's an example in the real estate space? Well, an example from the mortgage
Zillow,
space would be
Realtor.com.
like a Loan Depot or something,
Yeah.
or a lending tree rather. So you've got lead generators who in the past were running ads online, driving traffic to a landing page, which would ultimately have a TCPA opt-in disclosure and contact information fields and the like, and consumers would type in their name and phone number and click agree, and that would allow multiple brands to call because the TCPA disclosure itself, or perhaps a hyperlink partners list linking to a longer list, would contain multiple brands, all of whom the consumer was giving consent to make contact. Some brands would say something like, by clicking agree, you're allowing up to 4 of the partners on this list call you. Or sometimes it would just say any one of the, or all of the marketing partners on this list to call. So that model is going away, or at least it will be more difficult. Beginning on the 27th, you need one-to-one consent to use any form of auto dialer to call anyone for marketing purposes. And so, thankfully, what is an auto dialer is somewhat limited. Not every dialer is an auto dialer. Some dialers are auto dialers. They call it an ATDS, automatic telephone dialing system, and some are just not. You have all these manual, cloud-based or VoIP-based click-to-call systems. Preview dialing, etc. Most of those are probably not auto dialers, depending on which particular platform and which mode you use. And which state you're in sometimes matters, because the courts have interpreted what is an auto dialer differently in some cases. But that's the biggest part of the rule, is that you cannot get one-to-many consent anymore. So anyone on this call that is currently buying leads from a lead generator, or maybe you're generating leads yourself for you and multiple partners who are offering different sorts of real estate or help or home services and whatnot. But the new standard is that the exact seller brand, like a real estate agent or agency, for example, has to be listed at the time of consent. And if there are multiple brands listed, let's say your lead generator is selling leads to 20 different real estate agents in your state or region, then each one would have to be listed with its own unchecked checkbox, or its own agree button or submit button, etc. So the consent has to be one-to-one going forward and not one-to-many. It doesn't make real estate prospecting by phone illegal. It doesn't mean you can't auto dial. It doesn't mean you necessarily can't call numbers on the D&C list. It's just that the standard of consent, the definition of what is sufficient consent to do those things has gotten a little bit more difficult.
I gotcha. And Eric, thanks for that definition. And I think because I'm glad you mentioned that. You said a phrase there, oh, cold calling is illegal. That is how someone explained it to me. Like, Gus, what are you going to do? Cold calling is now going to be illegal. And once I discovered, I dug it. This was months ago. I dug into the TCPA rule change. My interpretation, it had nothing to do with cold calling. Right? At least this change, right? The one-to-one consent had nothing to do with anything that, related to cold calling. The cold calling stuff didn't change, right? That didn't change. But this specific update was specific to what you mentioned, opt-in leads, right? It's kind of closing some loopholes that were in around opt-in leads. Because and trust me, I knew about that. That ability. You could buy lists, right? Even for cold prospecting, you had third-party consent for to call leads from who knows where they got the consent from, but you could call them for your purpose, for a completely different purpose than what they had opted into, right? So I think that's going away. But if you're doing consent-based leads and auto dialer, correct me if I'm wrong, but both have to be true. Like for these new rules to apply, both things have to be true. You have to be dealing with an opt-in lead, and you have to be dialing with the definition of an automatic dial. Is that correct?
Yeah, you're exactly right on both points, if I understood you right. So the new rule technically only applies to quote unquote regulated technology. That means three things. One, initiating a call or sending a text message. I saw someone's question pop up about texting. This does apply to automated texting equally, like it does to automated calling. So regulated technology means using an auto dialer to send a text or make a call. That's one trigger. Two, deliver any pre-recorded message during a call, even just a brief one, like a ringless voicemail message, a pre-recorded message that you push a button to manually leave on a voicemail box or answering machine, avatar, soundboard, anything that delivers a recording, even for just part of the call, and even if it's manually from a human, constitutes a pre-recorded message and is another trigger. The third trigger is an artificial voice, which includes AI. The AI is a big, sexy, cutting-edge topic now, and the FCC just, I want to say 5 or 6 months ago, officially ruled that calls conducted using any form of generative AI fall under the definition of an artificial voice. So you've got sending a text or dialing a number with an auto dialer. That means you're using regulated technology, or delivering a recording, or delivering or using an artificial voice or AI. And this is all outbound. And that's what regulated technology is. So if you're not using regulated technology, meaning you're not auto dialing, delivering recordings or AI, then you're subject to the rule. Cold calling, again, if you're not auto dialing, then cold calling is unaffected. The only form of cold calling that would be affected is if you were auto dialing, in which case you don't have any level of consent, so your call is going to be illegal, regardless of what the consent definition is. So you're right, Gustavo.
100%.
Gustavo and Power ISA have always kind of been made compliance a priority, and that's probably why you've had such a good track record. I've never had to
I know.
defend you
Knock
in
on wood.
yours
I wish I
in
had some
court
wood
yet,
paneling. Yeah, I wish I had some wood paneling to knock on because it's been a pretty good
Yeah,
run.
knock on wood, cross your
Yeah, I
finger.
know. Yeah, and thanks for that definition because I think there's a lot of confusion, around that difference. Cold calling is unaffected by this change, but the cold calling didn't change, which means it didn't get worse, didn't get better either, right? This is
Right.
kind of the same.
Yeah.
And just keep in mind, I like the word you use, triggers. The triggers for this, right, are the ones that you mentioned, the opt-in leads for these new changes, or an automatic dialer for kind of any calling, right? Is that kind of the thing people want to go again? One way I've heard it described, Eric, I don't know if you agree with this or not, is that the rule changes in this legislation, what it wants us to dial slower. It doesn't want us to use robocalls, right? Like the stuff everyone hates. And it wants to kind of force that behavior where you pick up the phone, you call some people, and you actually try to make a connection with them, right? Like the activities most real estate agents do, right? I'm going to go on a limb here and say most agents, that's kind of what they want to do, right? They're not doing 10-line dialers. They're not doing 5,000 calls a day, dropping automatic messages, robocalls. They're not doing that, right? So that's my interpretation of it. That's what the legislation, that's the intention, the spirit of it. Slow it down, authentic connections, actual calls you intend to talk to someone with. And if you can do it off a single line dialer, whether that's a VoIP dialer or your cell phone or your ISA, that's what we do, ISA. If they're doing off a single line dialer, that's the safe zone. Am I right on that, do you think?
Yeah, that's exactly right. The new rule attacks robocalls specifically. So if you're not robocalling, i.e. using regulated technology, any one of those three triggers, then you're not robocalling, you're not auto dialing, and you don't care about the new rule. It might still be a best practice if you're relying on consent to get around the national do not call list or any one of the 11 or 12 state do not call lists. There might be a good reason to try and up the level of consent you're getting on other fronts. But strictly speaking, the new rule only attacks robocalling, thankfully.
I got you.
I
got you.
saw
Yeah,
a pop-up about the executive order signed yesterday. I'm happy to talk about that at the right time. That's one of the three silver linings I had on my list of
absolutely.
possible hope.
And
Yeah.
we're going to get those. That's another thing. I wanted to. I wasn't sure you're ready to jump on that or not because we I mean for better for I'm not. I don't want to get political, but we're getting an administration that tends to be more business friendly, right? Yeah, it tends to be not regulation friendly, not and more more for lack of a better term, more business friendly, right? So I think that's definitely going to have an impact either on the rule itself or the enforcement of the rule, which I think is kind of a big thing too. But Eric, one thing I want to clarify for folks, and this is important, when we talk about TCPA for real estate agents, small business owners, we're not talking about the government coming after us. I think I want to clarify that. I get for as a real estate agent, your risk isn't that the FCC or the FBI is going to come and investigate you. It's just not going to happen. It is a civil a procedure, right? Someone sending you a demand letter saying, hey, you violated either DNC or this new rule or some other rule, and you owe me $1,500 or $4,500. You did it 3 times, right? It's individuals going after you, not the government. Can you talk a little bit about that? Is that correct?
Yeah, that's mostly right. So the biggest risk for telemarketers or any business engaging in marketing over the phone is a private consumer filing a class action lawsuit. So one person who gets one illegal call can go find a plaintiff's TCPA lawyer, someone that's the opposite of what I do. And if they can sell them on the case.
I missed your phone call, but if you
I'm
need
hearing
me
some
your name
background.
and number with a brief message, and I promise I'll get back to
There
There
we
we
go.
go.
Got it.
In any case, where did I leave off? Sorry, Gustavo.
Oh, yeah, you're trying to defend against someone that creates a class action,
yeah.
right?
The biggest threat is that one consumer, one homeowner in your industry might get one illegal call or believe they got an illegal call, whether it's because they're on the do not call list and or they thought it was auto dialed and or they thought you called after they said stop calling. Those are the three big triggers for litigation. They can find a plaintiff's TCPA lawyer and file a federal TCPA class action lawsuit and drag you into court for sometimes years. TCPA plaintiffs often get at least a full year of discovery where they get to subpoena and demand from you your call logs, your SMS logs, your scripts, your client lists. They get to depose you under oath, et cetera, and try and find any little mistake you made going back 4 years. There's a 4-year statute of limitation for TCPA litigation. That's the biggest risk. Technically, government agencies could still come and fine you. The FCC and FTC and state attorneys general regulate telemarketing, just like state divisions of real estate regulate real estate agents. They have behavioral rules. They could, if a client or homeowner complains about a real estate agent, that consumer can go to a division of real estate and or a state attorney general or FTC and complain about a business, and those regulators might investigate and might issue a fine. But by far the biggest risk is a private TCPA lawsuit. You're right.
100%. And for most agents, it's the action they take is they get that demand letter, and I mean, where do you go from there, right? So yeah, 100% agree with that. So Eric, a specific case of this, I think there's a lot of confusion around this, is what happens if let's say you're working with a company like a Zillow.com or Loan Depot, these resellers, and they become compliant next week, right? They're $1 billion companies, they're gonna become compliant. Okay, great, going forward. You, in the meantime, maybe you've been buying leads from them for 5 years, 3 years, 2 years, right? Years of leads. You might have thousands of leads. Some of my clients have tens of thousands of leads from these vendors. They did not get one-to-one consent for them in the past. My question would be, for someone that has a large amount of, I call them aged leads, old leads, how does that change, right? Because you don't have one-to-one consent with anyone in your database starting January 27th. No one has one-to-one consent, right? So what is the approach when you're calling and reaching out to old leads? How should we approach that?
Yeah, so unless your lead generator modified their opt-in process to comply with the one-to-one consent rule early, which some brands did. This rule was published a year ago, passed a year before that. So some lead generators have already switched from multi-brand consent forms to single brand consent forms, or multi-brand forms where each real estate agency or name has its own checkbox or similar. But assuming your lead generator didn't do that so proactively early on, then you're right. Those opt-ins are technically invalid beginning on the 27th. So kind of a retroactive effect. The good news is it's not illegal to call those people, those numbers. It's just you've got to dial manually.
Yeah.
And for
100%.
separate reasons, you've got to scrub national DNC unless unless your old opt-in was still good enough for DNC, which arguably your old multi-brand standard of consent is probably still good enough to get you around the do not call list, at least in the eyes of the FCC. Now, the FTC in certain states may take issue with that, but Big Bag FCC has a completely separate standard of consent that you need to get around the do not call list. In fact, you don't even necessarily need consent. There are EBR, they call it EBR exemptions. The established business relationship, there are two types, inquiry EBR and purchase or transaction EBR. So even if a consumer has never given you or your lead generator fancy written consent with a TCPA one-to-one disclosure, if they made any sort of product or service inquiry, like an inbound call to ask questions, like they attended your own webinar as a homeowner and asked you about how do I list my home or sell my home, etc.
Or
Any
maybe
consumer,
attended an open house, Eric, right? Attended an
yeah,
open house. You guys, you
they
made a
attend an
connection.
open house, fill out a card, leave their business card, whatever it is. If they make a product or service inquiry, even if there's no fancy signed written consent or web form opt-in, then you get 90 days to ignore the fact that they might be on the do not call list without any written consent. So you can use things other than written consent to get around the do not call list, including EBR, but you would not be able to auto dial at all. Like you can't send a big voice broadcast campaign or send a bulk text blast or send pre-recorded messages or use an auto dialer that's calling, like you said, 100 numbers at a time or something. You really gotta, beginning on the 27th, if you don't have very well documented one-to-one consent in hand, then you need to absolutely not auto dial or auto text, not deliver any recordings or AI. And then, of course, you're still checking for DNC. Can I call a number on the DNC list? You haven't brought it up yet, but this is another big challenge under the TCPA that has nothing to do with the one-to-one consent rule. So for a few years now, most regulators and plaintiffs' attorneys have started treating all real estate prospecting calls, even home buyer calls, where they're not even trying to get a listing fee. They're just calling to buy a house. All of these real estate related calls, whether on the traditional side or the investor side, wholesaling side, they've been all lumped in with telemarketing. So even if you call and you start the call with, hey, are you looking to sell your house? If there's any chance you might want to take a listing fee as plan B or C, it's absolutely treated as marketing, even if you are purely calling for
Because
bot.
I have heard that. Oh, it depends on the script. What you're kind of saying is that for real estate, it doesn't really depend on the script. You know, 'cause we're trying to seek, and that's I've always fallen on that side of that discussion because people will argue, oh, I'm not trying to offer a service. I'm trying to help them sell their home. Like, I don't think so. That's a little
Yeah.
it always felt like wishful thinking. I'm glad you're confirming that because that's what I've always told people. I don't buy that it depends on the script. If you're a real estate agent making that call, it's just unlikely that that wouldn't be considered, a telemarketing call. So let me run real quick, Eric, through some of these questions, make sure we're hitting everybody. We have about a dozen messages here. So one question from Garrett: are triple line dialers like Mojo, adaptive dialers like Call Tools? These are really common dialers in the industry. Is it okay to use them with the new TCPA guidelines? Or a better question is, what's the definition of an automatic dialer? How can Eric? How can you tell? Because right now I can tell you from what we're talking about, Mojo or Call Tools fall into that definition because they're multi-line. They might not be predictive. They might not have a predictive mode, but they are multi-line power dialers. So Mojo and Call Tools. Does that sound correct?
Yeah, that's at least partly correct. So there is some gray area as to what an ATDS, automatic telephone dialing system, or auto dialer is. There are certain things we know are auto dialers. There are certain things we know are not, and then there's this big ambiguous area in
Hmm,
between because there's all sorts of variance in technology. We've
of
represented
course.
over the years probably virtually all dialing platforms in the real estate space.
Wow.
Mojo's triple line, but there's a whole bunch of players in that space. Land Voice,
Yeah.
RedX
Red X,
slash Rave
Vulcan.
slash Revin or whatever they're called now. Uh, let's see what else. Phone Burner. Um, there's a host of technology platforms. I would say certainly if it's one to one, like one click calls one number at a time, then it's extremely unlikely that's an auto dialer for purposes of the TCPA. To the participant's question about triple line dialers like Mojo, that's where you get into this gray area.
Hmm,
There is manual human intervention to initiate the call, but you're really initiating three calls, and then you have call abandonment, almost like a very aggressive predictive dialer has call
correct.
abandonment. So, is a multi-line dialer an auto dialer? I still have to say some probably are and some probably are not, but there is a distinct risk that as soon as you are dialing multiple lines at once, meaning you're going to have call abandonment. Called person number A picks up the phone and then B does, but you're already talking to person A, and maybe C does too. And so it drops those calls or plays a recording or however you configure it. That's dangerous because whether or not you win that argument in court, a lot of consumers who get a dropped call or there's a pause or a beep or anything like that often just make the assumption, oh, you must be calling me from an auto dialer. This must be a robocall
Yeah.
and I don't know who you are, so you must be breaking telemarketing law. Let me go file a complaint or send you a demand letter or start calling lawyers or my state AG or Division of Consumer Protection. So single line click to call dialers will always be safer than multi-line dialers. Admittedly, a manual triple line dialer is going to be safer than some dialers, like that just blast pre-recorded messages or are calling, 100 consumers at a time when you've only got 5 agents in the call center or whatnot. So yeah, the safest way to avoid the definition of an ATDS is to use a manual one-to-one dialer. If you need to use a triple line dialer, you just want to vet that platform very carefully. You absolutely do
Yeah.
not want to deliver pre-recorded messages. I remember representing Phone Burner a few years back when the FCC sent a letter to all the major telephone carriers saying Phone Burner needs to be turned off. Oh, and
Oh,
overnight,
wow.
5,000 plus real estate agents, their phones wouldn't ring, even for inbound, some of them. And it was all over the actions of one of their many real estate agency or broker clients who was delivering a lot of pre-recorded messages. That was one of the main causes of that lawsuit is that even if the call was manual and even if nobody thought it was an ATDS or auto dialer, um, they were using the dialer to deliver recordings, which was a separate trigger. It brings you back into regulated technology,
Yeah,
even if you call
100%.
manually on a one-to-one basis.
Yeah.
So I also saw Mojo got sued right along with Coldwell Banker as a co-defendant a few years back. Um, a lot of it is, it's not like a dialer is illegal or legal, compliant or not. It's how you use it. You can use
Gotcha.
perfectly compliant manual dialer to break the law. Like if you
I gotcha.
deliver a recording without consent. You can use a manual one-to-one dialer to call someone who's already opted out. That's illegal. Or you could lie to
Yeah.
someone, which is a misrepresentation and violates a bunch of consumer protection laws. But yeah, to your point, the safest way to avoid falling into the definition of an auto dialer is to use a one-to-one dialer. If you use a triple line dialer, you may want to end up excluding certain states. For example, just as an example, Maryland and Oklahoma right now have broader local definitions of an auto dialer than the federal.
Oh,
In
wow.
those states, if the dialer stores a list and prompts the agent as to the next number that should be dialed, like a lot of preview dialers, they present one number for the agent and say, okay, click to dial this number, or with a triple line dial, click to dial these three or whatever it is. The automatic selection of the next number to be called is enough to make the system an auto dialer in Oklahoma and Maryland. Florida had that same rule, but they quickly fixed it when they saw that a lot of frivolous lawsuits were being filed over what appeared to be really manual calls and texts.
I got you. I got you. Awesome. Thank you for that. We got another question from Chris Lynch. Is a dialer system like Vulcan, Mojo, Red Cat? So I think related to the last question. So I think your answer already kind of got that one. If I think Vulcan, Red X don't have multi-line capabilities, so I think they're on the safer side of that spectrum. Like you said, Mojo is kind of in the middle. I actually asked Mojo directly, said, "Hey, Mojo, do you have any comment on this?" And I think they have him kind of trigger. Anyone mentions TCPA, they go to this huge, generic blob, doesn't
Yeah.
really say anything, right? So understandable. I don't blame Mojo for that. So let's see if another question. This is from Daryl. If a FISBO is selling their property, posting it to the public and including their phone number, would that be implied consent? That's interesting. Yeah, our FISBOs, if you're calling a consumer, for sale by owner, that's advertising their phone number, they might be on the DNC, but they're saying, "Hey, call me. I want to sell my home." Is that considered under any of this any TCPA rule? Would you break any TCPA rule if you call them one-to-one, like a manual call?
Yeah, so it does. A person listing their house as for sale by owner does not give you any consent, especially not one-to-one consent for auto dialing. So that's clear.
Yeah. Okay.
What's less
Perfect.
clear is if you're allowed to call FISBOs that are on the do not call list manually.
Mm,
We tell all of our real estate clients that the safest approach is always to scrub DNC. But I have some that have taken the position a little more aggressive. Look, I don't have a written consent, but I don't care because I'm not auto dialing. I'm calling manually, slowly, one at a time, very live in a manual calling environment. No auto dialer, no pre-recorded messages, no AI, etc. And I'm just going to disregard the fact that they might be on the DNC list because they voluntarily published their number, almost like an open inquiry to
yeah.
whoever looks at that listing. The problem is, even if that flies with TCPA and FCC, you have some states that have specifically come out and said, no, 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 no. A person listing their home or otherwise publishing their phone number to the public doesn't get you around the do not call list. So for purposes
Hmm,
of the federal TCPA, while a person who has an active FISBO listing um, might not be able to sue you under the TCPA, they might be able to still complain to their state who
gotcha.
has more conservative, stricter DNC list rules. So I would just
Okay.
caution you to check this to particular state rules in the
Gotcha.
jurisdictions in which you
That's fine.
call. Some of you maybe are only licensed as a real estate agent in one state, so you only
Yeah,
care about your state telemarketing laws and the federal.
that's it.
Some others on this call might be licensees in multiple states, or maybe maybe you're a lead generator or an appointment setter or something for real estate agencies across the country, and you have to look at a broad, survey of law, something our firm can help with. But yeah, in general, you're much safer to call on a FSBO than like an expired listing, or if you're just buying raw homeowner data and appending phone numbers, or if you're buying distressed homeowner data, tax liens, or pre-foreclosure or something because you want to buy homes or wholesale homes to your investor partners. So yeah, I would say FSBOs are safer to contact as long as you do so manually. But I have some clients that won't even call a FSBO if it's on the do not call list. That would be the safest approach. Is if you're cold calling, scrub DNC. If you scrub DNC, yeah, you've got to buy twice as much data because you're going to lose half of those phone numbers to the scrub.
Yeah.
But it's better than playing Russian roulette, and you consider yourself lucky for months or years even, and then you eventually just call the wrong guy. You know what I mean? And he knows about some sneaky state rule that goes above and beyond the federal TCPA, and all of a sudden you have a state attorney general, or you've got a plaintiff's attorney suing you under state law. So we tell all our real estate prospector clients, go ahead and scrub consumer DNC. There's been a lot of litigation. I defended my first one, I think, was EXP. EXP's been sued in a number of class action lawsuits for DNC and other stuff, and multiple times. But at their first big class action 5, 6, 7 years ago, we defended. In any case, yeah, real estate has really come under fire for TCPA. 5 years ago, almost no real estate agents had heard about the TCPA, and now 99% do because they or someone they know, big brokerage mothership, has been sued or subpoenaed or received complaints or CIDs and whatnot. So yeah, scrub DNC, but yeah, a FSBO is definitely in a safer category than if you're buying raw homeowner data. As a best practice, we encourage you to scrub DNC, whether you're calling a FSBO or you just bought homeowner phone numbers from your hometown.
Got it. Understood. Another question from Garrett. Our text texting, like Eric said, is the same. TCPA holds them, equivalent, same thing. Everything would apply to texting.
Yeah.
Looks like Garrett got, okay, you're trying to text someone through Zoom, you got a message blocked because of 10 DLC. Yeah, that's a different, rule. That's, people that don't know, 10 DLC is a new, set of regulations for texting. So, so yeah, a little bit of a separate topic, but yeah, you got to make sure you register as a sender, and you should be able to send text messages through an automatic system. However, I'll tell you this from experience: if you go over a certain threshold of people opting out, like too many opt-outs, you'll also get stopped, right, from texting automatically, right? So it's also it's a regulated technology. Automatic texting is a regulated technology, and the same, people, they want you to do less of that, right? Less of that. So yeah, like I said, Eric, they want us to move a little bit slower, right? That's the intention. I think in real estate, there's a tendency, a desire to want to get the automatic texting it's my fault too. We do AI calling, right? AI calls and automatic texts and all these bots, and we want everything to be automatic and massive. The problem with that is that these technologies can be abused very easily for very, very, for good purposes, for fraud, for many things, right? So, like I said, the legislation is trying to get us to just slow down a little bit, right? If you focus on slowing down a little bit, having authentic conversations, authentic connections, I'm not a lawyer, but my thought is you're gonna be following the spirit of this law. Great. Got Abigail. Does this affect real estate recruitment? Or you know what? I'm gonna expand on that, Eric. B2B calls versus B2C calls. Is there a difference there when it comes to TCPA?
Good question. So B2B calls and texts are subject to some of the telemarketing rules, but not all. They have a lot of exemptions. So for example, business landlines, not dual purpose lines that are primarily personal and they just occasionally make some business calls with that line or something. But a line that's genuinely a business landline, a business phone connect that's not a wireless phone, and it's owned. The subscriber of the line is, Eric Allen LLC, and not Eric Allen, the individual person. Business landlines have literally no protection under the TCPA whatsoever. So some states, again, might be stricter. Washington State, California, I think. There's a few states that have local laws that do provide some protection for business landlines, but the feds provide no protection for a business landline. You can auto dial a business landline for marketing without any prior consent or prior EBR, established business relationship. You can deliver recordings. You can do AI, ringless voicemail, avatar, soundboard, etc., to a business landline. Again, except in some stricter states. Business cell phones, though. Business cell phones have the same protection as consumer cell phones, unfortunately. So since October of let's see, 2013, wow, a long time ago. Since 2013, all cell phones are considered super sacred under the federal TCPA. You cannot auto dial or auto text any cell phone, consumer or business, or a mixed use dual purpose line without prior express written consent, which consent needs to be on a one-to-one basis beginning a week from now. Now, the do not call list. This is the tricky one. 5 or 10 years ago, we were telling our real estate clients and real estate lead generator type clients that if you're calling B2B, even if it's for marketing, and even if the number is on the consumer do not call list, you can ignore the fact that a business owner put a business line on the consumer D&C. Because technically, the D&C list, even if it doesn't have a way to prevent business owners from putting their business lines on it, technically the law just says it's illegal to call a private line or a residential line that's on the D&C list. So even if a business line gets added to the consumer D&C list inappropriately, because there's no way to prevent it, it's not illegal to call a business line on the consumer D&C list under the TCPA. But then, you know, since then, especially the last 5 or so years, there's this big problem with mixed use or dual purpose lines. Like my cell phone, I mean, I own this. Eric Allen, the person, is the telephone subscriber with T-Mobile, not Allen Mitchell and Allen PLLC. So even if the firm pays my phone bill, and even if 90+% of all my calls are for a business purpose, and not a personal reason or residential reason, and even if I put that number on, you know, my business card, my business website, if I'm a real estate agency and I use that number on file with the state where I hold my professional business real estate license, etc., even if I do all of those things, I might still feel like it's primarily my personal line, just to me. Like I might have my feelings hurt if I get unsolicited calls when I went out of my way to figure out how to put my number on the FCC's D&C registry. So we've been telling our clients for at least 5+ years now, even if you think you're calling a business number, scrub consumer D&C anyway. You won't lose half your data like you would on a B2C campaign. You might only lose maybe 10-15% of that data because it's B2B. But that'll reduce the chances that you accidentally call a residential line or a mixed use line that's used for business and personal reasons when you're really just trying to call business lines. So yeah, B2B is exempt from a lot of rules, has no protection for business landlines, but business cells have the same protection as consumers. You need one-to-one consent if you're auto dialing. But then for D&C, it's just a very, very strong best practice. We defended so many cases where, in many different verticals, not just real estate, but you know, we've got a lot of B2B clients that sell merchant processing, or they build you websites, or they get you small business loans, whatever it is, light bulbs. If you're B2B, the consumer do not call list was not intended or designed to restrict your calls, but you don't want to risk calling a dual use line and getting sued and having a 2-year fight in court trying to convince a judge that the line was more businessy than personal, and vice versa for the plaintiff. You don't want to have that fight. Win or lose, you don't get back the money you paid me or some other TCPA defense lawyer. So just scrub consumer D&C, even for B2B. Thankfully, if your data source is good, if these really are business lines, you'll lose less to a consumer D&C scrub than you would on a B2C campaign.
All right, I love it. And let's make sure we hit on those, because the next question was around executive orders. Actually, Abigail asked a few more questions, but I think Abigail, we got to those because she's asking about existing business relationships. Eric kind of touched on that because she's saying, hey, can we reach out to past clients? You can definitely do that. But she specifically asked about voicemail drops. Remember, voicemail drops are a regulated technology, right? So I would kind of be maybe nix that as part of my outreach plan, because it's saying they use that to confirm giveaway orders to past clients. I think you're using that regulated technology is going to get harder. I don't. I mean, this is me speaking for my own. I don't think a past client's going to sue you for TCPA. That's just me talking, right? I would think on the risk spectrum might be on the lower side if there's an existing business relationship and they're a past client. But I think the general advice would be to kind of be careful with those automatic voicemail drops, because that is a trigger, right? Eric specifically mentioned
even if the call was made manually from a manual system, like a one-to-one click-to-call dialer, and even if a real human conducts that whole call, as soon as the human presses something to play a recording, even if it's just to a voicemail box, that's as if the whole call was a pre-recorded robocall, a voice broadcast, unfortunately. Yeah, so ringless voicemail and the manual leaving of pre-recorded messages on a manually dialed call. As soon as you do anything pre-recorded, AI, automated, artificial, any of that, you're using regulated technology, and you need fancy one-to-one consent. EBR gets you around the do not call list. So having an established business relationship gets you around the D&C list, but not the dialer rules.
Okay. And you mentioned some silver linings, because the next question was around executive orders, how that is affecting it, and what do you see as positive news? There's not been a lot of positive news in this call. What do you think?
Yeah. Yeah, it's not all doom and gloom. And honestly, those of you on this call who care about compliance and aren't just trying to make a quick buck and then disappear in a few years and flee the country, if you want to do this long term, you're smart for being on webinars like this and having great compliant technology partners, lead generators, etc. And so you're going to survive. It's your competition, I'm hoping, that gets sued out of business and not you here. I hope I'm not preaching the choir. But yeah, some silver linings. This is from an email I sent a few clients this morning. Literally last night, a relatively new telemarketing trade association called REACH, Responsible Enterprises Against Consumer Harassment, or something substantially similar. So REACH last night late filed an emergency new petition with the FCC. That petition was based on President Trump's executive order that he signed, saying, they're calling it the freeze order or something, but it basically said all federal agencies, and this was sent to the FCC as well, federal agencies, we would like you to seriously consider postponing enforcement of any new rules and regulations that you've already passed, including if they're already published in the Federal Register, like this one has for many months now. So basically, Trump was saying, hey, FCC and other agencies, if you've got new rules in the works or passed but not yet in effect, like the one-to-one rule that isn't in effect for one more week, we would strongly urge you to consider stalling or postponing enforcement while we have time to get in and make changes and whatnot. The problem is the FCC, while it's designed to have 5 commissioners, 3 from the president's controlling party, the majority party, and 2 from the minority party. Right now, we only have 4 commissioners, and it's tied, 2 Democrats to 2 Republicans. President Trump recently announced his, I've got her bio up. He intends to appoint Olivia Trusty as the 5th commissioner to break the tie. And that was quick. His appointment was very quick, but Congress will hold ratification hearings, and until Congress ratifies that appointment, she won't be able to take her seat and break the tie. So one silver lining, although I'm not betting on it, but the FCC, even though it's tied, could choose to stall enforcement to wait for Olivia Trusty to come in, and she could be the tie-breaking vote that could undo some of this, perhaps. Again, I wouldn't count on it. I would assume that the new rule does take effect next week on the 27th, but you've got that emergency petition literally filed late last night, merely hours ago, saying, look, Our new
Stop.
president has specifically told federal agencies, including you, FCC, don't put into place any new rules, even if they were passed before I became the president. Let me get my folks in and let me reevaluate the work you did recently, and we'll see. So there's always a chance that the FCC could act before the 27th and say, yeah, we'll postpone this a couple months or something. In fact, the appeal, or not the appeal, the emergency motion to stay specifically asks for at least 60 additional days. So just 2 extra months, give the president time to try and get his the new commissioner appointed. You've also gotten, this is a good segue to silver lining number 2. And this didn't come up in the context of real estate, of course. This was actually in the insurance vertical, but I don't have the petition up, but the IMC, the Insurance Marketing Coalition, a trade association of 100 or so insurance companies and lead generators, sued the FCC in federal court last year. And that appeal was briefed in writing for many months. And then literally just a few weeks ago, well, I think it was maybe a week before Christmas or so, the 11th Circuit Court of Appeals heard oral argument. So the lawyer for the IMC showed up, and the lawyer for the FCC. And wow, I just re-listened to that half an hour of oral argument, the hearing. The Commission of Justices in the 11th Circuit, where they asked very, very tough questions, primarily of the FCC lawyer. They spent 25 minutes grilling the FCC lawyer, and only 5 minutes with the IMC's lawyer, and asking friendly questions based on their questions. I mean, the 11th Circuit justices, I think, are viewing the new one-to-one consent rule with a lot of suspicion. Their questions were all about, okay, FCC, we get that there's a problem with robocalls. We get that technology's made it easy for consumers to be harassed and get calls they didn't want. And we think your new one-to-one consent rule is coming from a good place. It's trying to slow down robocalls and this aggressive new technology. We're trying to close the lead generation loophole by getting rid of this. It was really a problem with insurance. You'd have a lead generator who would have a 2-sentence TCPA disclosure on a website and then a hyperlink to 5,000 or more insurance company. They would list every conceivable insurance company they've ever worked with or want to work with, because they have no idea who they're going to sell the lead to. And that was becoming a problem. A consumer would go online for 30 seconds requesting an auto insurance quote, and then would start getting calls from 30 different insurance companies to sell all sorts of insurance, calls and texts, and they'd opt out from one, but the other 29 would keep calling. And so they were really trying to slow regulated technology down by closing this lead generation loophole. And the justices were like, we get that, FCC, but doesn't a consumer as a citizen and under our law and constitution, can't a consumer decide whether to provide multi-brand consent or not? Couldn't a consumer who goes on a website say, yeah, I want a lot of auto insurance quotes. Everybody can call me for the next little while because I want to get a lot of competitive information. So the questions were really pointed at emphasizing that there could be unintended consequences. This could harm consumers.
Overreach.
If I'm a homeowner and I want calls from 5 real estate agents instead of just one, then I should be able, with one click, to give permission to all 5. I shouldn't have to go click, 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 or unclick, or whatever it is. So the questions were really tough. We're so close to the 27th that I think it's very unlikely the 11th Circuit will rule before then or issue a stay, but it's possible. And their questions seem to really attack the FCC, even if the rule doesn't get postponed, or let's say the 11th Circuit issues no ruling in the next week. The rule will go into effect. Lawsuits will start getting filed on the 27th against people who auto dial on the 27th without one-to-one consent. But maybe the 11th Circuit, takes another few months and then rules to undo what the FCC did.
Walk it back.
There could be some relief on that front. So we've got this REACH emergency petition to stay enforcement. You've got the 11th Circuit lawsuit challenging the FCC that already was fully briefed, and the oral argument held a few weeks back. and based on the questions, it might come out favorable. And then finally, um, just remember that in time, once the FCC is fully constituted again and the new commissioner is appointed and takes her seat and starts issuing new rules, at that point, the FCC could make new rules undoing what they did under the old administration, or perhaps Congress passes laws that change the TCPA statute itself. Congress can always decide the FCC has gone too far, done something wrong, missed something, created unintended litigation, unintended consequences, and could literally just change the TCPA itself. The FCC doesn't get to change the TCPA, only Congress can do that. The FCC just gets to interpret it and issue regulations kind of fleshing out and clarifying it. So Congress in time, again, this isn't going to happen before next week, and it probably won't happen in the next few months, but in the next couple of years, you could have Congress saying, okay, TCPA litigation is destroying legitimate American businesses who just want to reach out in an efficient way to advertise their products and services or contact their own existing customers quickly and efficiently.
Yeah.
This, this is the new TCPA. Deal with that, FCC. That's also possible. All of these are potentials, you know what I mean? I would, to be safe, we should assume that nothing will change before the 27th. So you should be getting one-to-one consent if you intend to keep auto dialing or delivering recordings, including just to voicemails, beginning on the 27th.
Okay, I love that. And let's get through a few more of these questions. I think we've handled a lot of these. Rob asks a question about Mojo. Rob, we addressed Mojo specifically. There's some aspects of it you should not use, even if single line dialing, and the multi-line can fall in kind of that gray area. Alan, what if you're generating leads on your own website, right? So that's a pretty good question. Alan, the real estate agent, is asking, hey, what if I'm running my own lead gen? I'm not buying leads from anyone. I think if you just have the right language, you should be good to go, right, Eric?
Yeah, that's exactly right. Our law firm owns 30, 40 websites on different topics about telemarketing law where we publish free information. All of those have a little contact us form and a little tiny disclosure. If you got the right disclosure and you don't sell that lead or share it with a third party who's going to auto dial, and you honor opt-outs, you don't lie to people, you're perfectly safe. Yeah. So your disclosure just needs to be clear that you're going to call them. Like, it can't lie and say, we're going to send you informational stuff if you want to market, but that's just common sense, Yeah, you can generate your own one-to-one consent on your own very simple little GoDaddy website. It doesn't have to be super sophisticated. You've got all these big lead generators that are using these third-party opt-in web session recording vendors, Journia, Trusted Form, Permission Trust, and to document the consent. You don't need that as a small business owner who's just collecting inquiries on a contact us form on a website. If you own or control the website and only you are getting that opt-in and only your brand name is in that disclosure, and that's the name you're going to use on the phone, and that's the business name that's on the listing agreement, you're golden. If you've got that right consent and it's well documented so you can prove it later, that's the other part of it. You want to be compliant, get consent. Could you prove you had consent 3 years later if the lawsuit comes then? If everything's done right, which is simple in that example, absolutely. And then with that level of consent, you can ignore the do not call list. You can use all the regulated technology you want.
All right. Love it. And there's several questions around a similar issue, which is a lot of these CRMs, the big real estate CRMs, Follow Up Boss, Lofty, etc. They've got a single line dialing capability, but they can create calling lists, right? You'll select, a dozen or 100 or 1,000 leads, and it'll create a specific calling list, but you click to dial through each one of those. So as long as it's click to dial, you should be covered when we're talking about automatic regulated technology, right, Eric?
Yeah, that's exactly right. The exception being, I mentioned this, Oklahoma and Maryland say the dialer can't choose the order. The human has to see the list or maybe a meaningful subset of the list, let's say 5 numbers, and then the human gets to click, the agent could click the last number first and work bottom to top to bottom at random. In Maryland and Oklahoma, if you're prospecting in those 2 states, you want to configure your dialer such that The dialer doesn't pick the order. The agent selects the order. Another workaround, if your current platform doesn't have the functionality to show multiple numbers at once, if it only shows one number, you can attack it from the list side. You can say, okay, this is the list, but I'm going to take that list, not just in the order that it was dumped out of the dialer in front of me, but I'm going to curate it. I'm going to rearrange the list in my order. And that's the human selection of the next number to be called that I did ahead of time. The other option, of course, is not to curate or rearrange the list, but to just show the agent, the caller, several numbers at a time and let the agent pick the number. That's the fix for Oklahoma and Maryland. Everywhere else, again, you've got a spectrum of liability. You've got truly manual rotary phone, right? You know, my parents had a rotary phone on the wall, and you're sticking your finger in the little thing and twisting. That would be the safest. And then you've got like a desk phone, like a lot of us have. Then you've got like voice-based desk phones, and then you've got software, soft phones that are just a single line. You've got preview dialers, and then you've got preview multi-line dialers. You've got power dialers and progressive, then predictive, and then you've got full-blown broadcast, pre-recorded and whatnot. Where you've got to make a business decision if you're a real estate agent. How much liability do you want to accept? The absolute safest approach would be to use a rotary phone.
100%.
Not efficient, not going to make any money, not going to get enough listings.
Smoke signals, messenger pigeon, and then rotary
So,
phone, right?
do you
100%.
use Mojo single line or multi-line? Obviously, it's probably a little safer to do single line. You know what I mean? I'm not saying that just because you used a triple line mode makes you an auto dialer. We would probably win that case most of the time. But again, it's a gray area in a lot of states.
Yeah, correct.
So,
correct. Yeah. Got to be aware of those. And be aware
so
of the
if
risk.
you're really
Be aware of the
conservative, risk intolerant, then you go single line. If you're a little more aggressive and you put aside a little TCPA war chest to pay a few settlements here and there or pay a lawyer, then maybe you can sleep at night and make the business decision. I'm going to use a little bit more aggressive technology. And I realize that I might have to have a fight with a plaintiff or a regulator someday. And I might be sitting in a deposition or courtroom trying to convince an 80-year-old federal judge who knows nothing about telemarketing dialers, whether this is an auto dialer or not. If you're comfortable doing that, then you may be okay with it. So you've got to make a business decision based on information like this, and of course your own independent legal advice.
Yeah, 100%. Interesting question here. I don't know if you got a couple more minutes. There's
I have
like
all the
4 or 5
time you
questions
want.
left
Yeah.
here. Right, love it, awesome. Thanks so much, Eric. Is there, Stacy asked a question when we were talking about, FISBO and what constituted like a solicitation call or telemarketing call. She said, is there anything we can say as real estate agents so that, when we're kind of soliciting, it's not considered a sales call? From what you said before, I don't think there is, Eric. Did I misinterpret that? Because she's saying, hey, is there something we can do where it's not considered a sales call? But I think we want to do sales, right?
Yeah, I mean, the classic example is traditional real estate agents who really want to take a listing fee, starting their calls out with, hey, I want to buy your home. Would you be willing to sell me or mine your home? And then they say no or whatever, and they say, okay, well, let me list it for you. Let me represent you and just take a listing fee. From a legal standpoint, those calls aren't treated any different, but from a practical standpoint, the called party, the homeowner, might be less likely to view you as a scammy telemarketer if you call them about calling their home, than if you just call and say, hey, I want to list your house for a fee. So yeah, I think there are little things you could tweak in your scripting or your text templates or outlines to make you sound a little less telemarkety and a little more conversational, and you want to come across as their neighbor, the real estate agent down the road, without telling any lie. I mean, you can't mislead people. You can't make it sound like the sole purpose of your call was to buy their home when you secretly know that you want to take a listing fee from them. But I think if you're cautious, you could test or split test different scripts and see what is better received. And part of that might be just doing things to make you more distinct from a traditional telemarketing call where someone's like, hey, I want to sign you up for a magazine subscription. Which credit card do you want this on? You want to avoid sounding like that, and you want to sound more like their neighbor who noticed your house and thinks that it could sell above market this month. You know what I mean? So there are little things you can do as long as you're cautious and honest. But the law treats it, to your point, Gustavo, the law
Yeah,
treats it the same way. There's nothing
gotcha.
you can do or say different to change the fact that you've got to scrub D and C. Unless you've got consent or an established relationship, or it's a FISBO in some states, and you've got to have one-to-one consent. If you're using an auto dialer, I mean, the law treats the calls differently, and there's nothing clever you can stick at the beginning or end of the call to remove it from the
Yeah.
TCPA. It's more about your intent and your purpose.
Yeah, and again, this is not legal advice, but in my experience, again, we make a lot of calls, Eric. We make a lot of calls. If I were to kind of classify a little bit of a spectrum when it comes to like the risk profile, I've seen just not that many issues. When we're talking about FISBO or expired. They kind of, I don't know if they kind of understand where you're calling. I don't know, and they understand you're a local real estate agent, right? You're someone that could run into on the street, and for whatever reason, that just seems to, they're just way less likely to complain. But the exception to that, the other end of the spectrum for me would be something like Circle Prospect, where you're kind of calling the general population like a robocall would, right? Indiscriminately calling people. In my experience, again, this is, consult with your attorney. That is way riskier, right? That's because you don't really have a good reason to call them, right? Other than you're telemarketing to the masses. I would make my own risk spectrum of the several we've talked about today on these lists. The general population always going to be the riskiest list. The more specific purpose to call, like a FISBO, that's probably the clearest one, would probably be less risky, right? So, anyways, that's my take from my experience of making millions of calls. That's what I've seen. So I agree with you, Eric, 100%. I think that what you say and how you say it matters a lot, and having a purpose to call, I think people will usually will have recognized that in the past, right? So, love that. Let's see. Get a few more of these questions. If I had, another one of those FISBO questions, I think we already addressed that. If we had consent, 90-day rule. Can you talk a little bit? Thank you, Alan, for asking that question. So can you talk a little bit about what that 90-day rule means? Is that a standard? Are we speculating, or do you have to wait until this is settled in court? What is the 90-day rule?
Yeah, so this has been in effect since the TCPA was passed. So to get around the fact that the homeowner's number might be on the National Do Not Call registry, you can either have consent or an EBR. An EBR is an established business relationship. There are two types. This is already the law. It was the law for more than a decade. It'll continue to be the law after the 27th and has nothing to do with the one-to-one rule, which again is just about auto dialing. So we've got auto dialing rules, technology rules, and then the do not call list. And they have nothing to do with each other. So for getting around the do not call list, an inquiry works. There's two types. If they make any product or service inquiry, doesn't have to be a fancy one-to-one written consent with an e-signature and whatnot, but any product or service inquiry. We talked about this, an inbound call. They attend an event. You knock on their door and they ask a whole bunch of questions and you get their number and walk away. If they make any product or service inquiry to you as a real estate agent or your agency, then you get this 90-day inquiry EBR period to ignore the fact that their number might be on the do not call list. You can call and telemarket to that number, text or call, without any other consent or relationship. Now, if they actually like sign a listing agreement with you, or let's say you sell their house and take a fee, as soon as there's a financial transaction, then instead of just 90-day EBR, you get 18 months of EBR. So there's inquiry EBR that only lasts 90 days, 3 months. And then there's purchase or transaction EBR, which lasts a full 18 months. So you sell someone's house or help someone buy a house. From the date of that closing, you get a full 18 months to ignore the fact that they might be on the D&C list. Again, doesn't get you around the technology rules. If you want to auto dial, you got to have one-to-one consent. EBR only gets you around the do not call list. That's the 90-day EBR rule. That lasts, there are 3 states with no EBR. I think they are New Jersey, Wisconsin, and Indiana. Those are the only 3 states. New Jersey, Wisconsin, and Indiana don't have an EBR exemption at the state level. Everywhere else follows the federal rule. If you've got EBR, either type, you don't care if that number's on the do not call list.
All right. Awesome. Love it. We got a question from Will. I haven't hired an ISA yet, but I'm really close. How exactly does this affect your business? So actually, there were two questions around this. If I have an assistant making calls for me, or someone hires an ISA, a telemarketer, to work for them, does that change anything that we've mentioned before, Eric? The fact that someone else's help on your team is making these calls, and you're as an agent aren't making the calls?
No, so technically, in your use case, the quote unquote seller under the TCPA would be the real estate agent, the entity who has the real estate representation service and will take the fee from the consumer homeowner. The real estate agent is a seller. If the seller hires a vendor to generate leads or transfers or to make calls, that vendor is a telemarketer under the TCPA. Both are liable for violations. So a seller is liable whether the seller made an illegal telemarketing call or hired a vendor who makes a telemarketing call. Now, you might privately have like terms of service or a contract that says, I'm going to indemnify you, or you indemnify me, or I'm going to be in charge of compliance, or we both will, or whatever. But yeah, to the government and in the courts, both the seller, so a real estate agent, and the vendor who makes a call are both responsible to ensure that the call is not made without the right level of consent or EBR or scrubbing, as the case may be. I wanted to mention about FSBOs. If you choose to cold call FSBOs, even though in some states and some courts they would say you're not supposed to, but if you call a FSBO, then you want to absolutely do like a litigator scrub. You're not required to, but you never want to call someone who has sued a marketer or a seller in any industry before. But let me just throw that in there before.
Yeah, that's a good practice. That's a best practice.
But yeah, so real estate agents and their vendors are their lead generators, their call center vendors, etc. They're all subject to the TCPA. Whoever picks up the phone and makes the call or pushes the button to send a text has direct TCPA liability. Everybody else involved has indirect, or they call it vicarious liability. If the call was made on your behalf or with your permission, or you benefited from it, or you knew or should have known you had vendors breaking the law, you could be held liable for their acts. So it really puts a kind of a compliance responsibility on everybody involved, whether or not you were the one in the chain that picked up the phone and dialed the homeowner or not.
Got it. Awesome. They got that question, Will. Chris, again, so I have a real estate coaching company. If I use single line Redux dialer, should I still feel comfortable without too much for sharing my prospecting call to YouTuber? So, Chris is asking about, can it be doing calls with Redux? Redux is a single line dialer. So I think, unless you're using that, remember, there's multiple triggers. One of them is that ringless voicemail, artificial voice drop. If you're not using that on a single line, you should be good to go, Chris. Dan. So Dan has a really good question. So actually, Dan is one of our clients that uses AI to call, some of his database leads, right? So can we use an AI bot dialer for probate kinds of leads? Cold calling. This is, essentially a cold call, unless you get one-to-one consent starting next week. This is now a regulated technology. I think this is it would be like using like a robo dialing system to call these leads. So yes, Dan, that definitely, I think this changes it, right? I think we're gonna change that use case for the technology, for the AI, to really only be opt-in, like new opt-in leads. We're gonna have to go that, because you're gonna get express written consent to use an artificial voice. So I think we're gonna have to change the use case of that service, just given what Eric's talking about, what we're learning about these new rules. Unless we get some reprieve, right? Like a couple super lightnings out there. Unless something changes, it would fall under a regulated technology for sure.
Two exceptions, if I may.
Yeah,
yes.
Go for it.
You can use AI on an inbound call all you want.
Oh, 100%.
Just like if they call you, the entire call could be handled by a pre-recorded IVR system. And it could be handled by an AI bot. Also, on an outbound, you can still use AI if the AI doesn't speak to the consumer. So I've got a lot of clients who are using AI not to speak during the call, but to prompt the agent as to what to say next, or to monitor the agent's, to monitor the conversation, to watch for compliance problems or a possible opt-out, et cetera. So there are opportunities to use AI without consent, but they're limited. And in my mind, they're really only on an inbound call or on an outbound where the AI bot doesn't speak to the consumer.
Got it. Okay, that's good to know. Jorge has a good question, which actually is a good segue. What kind of attorney should I consult if I want to get specific legal advice on my business practices? So, well, you might want to talk to Eric. So, I mean, Eric, great. I mean, because you did a compliance audit for us, and that was super, super valuable. What is the best way for people to reach out to you if people that are listening? We provided some amazing information, tons of really, really great tips. But sometimes folks have very specific use cases they want to go over, or they want specific training, or they want to create some collateral for their team, right? I mean, I remember you telling us that one of the big requirements is for the company to have like very clear guidance on what your policy is, because you might have a bad actor in your own company, on your own team. You might have a bad actor, but if you didn't have any kind of paper trail on what your training is, you might still be liable, right? So, Eric, what's the best way for people to read? Oh, there you go. You're dropping some
I
information in the chat.
stuck my direct email in the comments, as well as one of our 30-40 websites with a lot of free information. I would say if you go to telemarketingcompliance.com, we've got topic specific and even state specific information. It's kind of limited. I mean, if state telemarketing law would, if we printed it all, it would reach from the floor to the ceiling in this tall office. But we put up some basic user-friendly information in layman's terms online. If you go to telemarketingcompliance.com, there are links to our other sites, dnclaw.com, robocalllaw.com, ringlessvoicemail.law.com. So you can try that, or you can email me directly. We always do a free half-an-hour phone consult, no charge. It's all privileged and confidential. You can ask me anything you want. We can talk in an unguarded way about your risk and past mistakes or your strategy going forward. We can help you make good decisions. And then we're here as a resource. We only represent telemarketers and businesses who want to engage in telemarketing. We're based out of Salt Lake City. So unlike there are not a lot of TCPA compliance lawyers out there, but the few that there are, most of them are in Los Angeles or New York City. We're in Salt Lake City, where it's relatively inexpensive to live and work and do business and practice law. So our rates are roughly half of what our competitors are. Not that there are very many, but yeah, we're happy to do a free consult for anyone who wants to schedule that. My email's in the comments. I did see a pop-up question about how long does an opt-in last? If it's done right, it lasts forever until they opt out or their number is reassigned. So do reassign number scrubbing if you want to be sure you're still calling person A who consented and not person B, the new owner of that line.
I love it. Yeah, and I've seen a few different vendors popping up for that, actually, right? People that are doing a lot of stuff under the new TCPA rules, and one of them is that, like doing reassignment scrubbing, which I obviously have not really seen anywhere, but that probably would be a really, really good idea. So
yeah, it's new. The reassigned number database was just created, I want to say, a year or two ago, and it's only for opt-ins. If you're cold calling, you don't care if the number just changed hands. But if you're calling on consent data, you absolutely, in fact, you have to scrub the reassigned number database every 30 days if you want to qualify for this special TCPA safe harbor for the accidental calling of a wrong or reassigned number. Yeah, a lot of these scrub vendors, the same scrub vendors that would do a DNC scrub or a litigator scrub, those same vendors can do a reassigned number scrub now for people calling on opt-in data.
Okay, awesome. That's great stuff. And one last question from Tamara. How does it apply to old leads that we generated through Facebook and other social media ads, where it does say they give permission for us to call? So, if you're generating leads through Facebook, Tamara, that you're generating them for yourself. Unless you're not like Eric mentioned, if you're not reselling them, right, and you have the right disclosure information starting next week, right, then you should be good to go. Eric, what's the good way to get the right disclosure? The one-to-one consent. If you're generating leads on your own, you're rolling your own, right? You're running your own Google campaigns to your own website, or you're running ad campaigns on Facebook, which you don't even need a website, right? You just have like a lead form. What's the right? How would one go about getting the right language? Talking to someone like you, how does someone figure that out?
Yeah, if you send me an email, I will shoot you back my preferred current recommended TCPA consent disclosure. I'll send you the exact words. There may be a few blanks in there for you to put your business name and the offer industry type and whatnot, but I will send you my preferred language. I'll read it to you right now.
Sure.
We get hired to write custom language, also privacy policies in terms of service. Your TCPA disclosure, to be most effective, should link to a more comprehensive privacy policy and website terms of use or terms of service that would have like a class action waiver, mandatory arbitration clause, limitation on liability, disclosures about how you're going to use and sell their data, etc. But let me just tell you, so this would comply with the one-to-one rule. So ideally, you'd have the contact info fields, name, first name, last name, phone number, email, etc. And then I agree to receive marketing. By entering your info and clicking I agree below, you provide your electronic signature, express written consent and binding agreement to our terms of use, hyperlink, privacy policy, hyperlink, and for single entity, Allen, Mitchell, and Allen Real Estate, LLC, along with its agents and assigns to email, call, and text you at the email address and telephone number you provided above or provide later, including possibly using an automatic telephone dialing system, pre-recorded messages, and artificial/AI voices with offer type, real estate related marketing offers and other info, including outside of normal calling windows, and even if you're on the DNC list. If you're texting the carriers, for 10DLC or short code, they might make you do extra things that the law wouldn't. But some carriers are making you say how many max 3 texts a day or something. So if for 10 DLC compliance or to get a short code or for some other carrier or Twilio or platform related reason, you might need that disclosure, maybe not. Same with reply stop to opt out, again, only for compliance with telephone carriers and 10 DLC and whatnot. Normal rates apply and consent is not a condition of purchase, as you can always receive info by calling us directly. This website may record your interactions with it, and future calls may be recorded or monitored. Again, might not apply to you if you don't record calls, and if your website's not using Jernaya or Permission Trust or something. Finally, there's a new emphasis on the e-sign act as part of the one-to-one rule. They made clear you need an electronic signature. If they don't sign an ink on paper, that's okay. But a verbal consent's not good enough. You've got to get an e-signature. So we threw this in. This agreement is legally binding, just like a signed hard copy, and will be retained in a format you can print or request from us later. You agreed to do business with us electronically, but you may opt out later. This website, that's a duplicate. Okay, so that was it. It's about 8 sentences or 8 lines. You could play with it a little bit. Like I could shorten it if you want to be a little aggressive. We could talk about that. Some of the disclosures might not apply to your particular
might not apply, right? Yeah.
per use case, but what I read to you would comply, and I'll send that little blurb to anybody who emails me.
All right.
Again, awesome. You want to adapt it for your use because depending on the technology you use and the data you're getting, you may need to tweak it.
All right. Awesome. Eric, I think we got to everybody. Wow. Thanks everyone for jumping in. Eric, thank you so much for being gracious with your time, helping everybody out. It's been a great one. Great information shared. I think we got to everybody's questions. Okay. Eric, thank you so much. And
thank you, Gus. Everybody,
to the
pleasure.
next one.
Yeah.
All right.
See you again soon. Thank you.
Thanks, everybody.